Can I take the prerogative of the moderator and say a few things, which is a bee in my bonnet, which is accountability. India was very good, as John mentioned, in the 1945 conference, raising the issue of the treatment of Indians in South Africa under apartheid. And we, as John pointed out, we in a way won the argument in the way the Committee on Apartheid and the Committee on Decolonization was set up. And thanks in that conference to the support of the United States, which wanted to break up the colonial empires at that point of time. France, Spain, Portugal, and the United Kingdom, which were very vociferous in opposing India's attempt to bring what they called a bilateral issue between them and South Africa into an international forum. Having said that, I think no country has been Simon Pure on the issue of international accountability. To a lesser or greater extent, all of them have been caught with their hands to the till, in the till. And but India is a special case. And this is where I fall foul of the pundits in the international legal division of the Ministry of External Affairs and all the other spook agencies which decide to work externally and internally to make sure there is no accountability. Our last periodic report to the UN Human Rights Committee, which is the most powerful treaty body at the moment, was given in 2001. It's the year of the Lord 2021. Rip Van Winkle, call it that, or call it the Indian version, the eternally sleeping Kumbhakarna. Choose your pick. We have just forgotten what a 4-year cycle means and just are waiting for 20 years to be exact to file our overdue periodic report. Second, in spite of Article 51 of the Constitution about us professing fealty to international law, look at our declaration on the right to compensation in the International Covenant on Civil and Political Rights. So you can imprison a person for 20 years, find him guilty or not guilty, most probably guilty, not guilty, or even without, or in preventive detention without any charge, and then release him without a cent or a rupee or a paisa in compensation. So we made a declaration. The word declaration is an Indian euphemism for reservation. They want to look like good guys. So compensation is not available. Then the issue of prosecution of perpetrators. It is like climbing a glass mountain. We have section 193 of the Criminal Procedure Code, further strengthened after the troubles in the Punjab in the 80s and early 90s, and now impossible to penetrate, strengthened by sections 5 and 6 of the Armed Forces Special Powers Act and different sections of the Unlawful Activities Prevention Act. I won't go into a long litany. This is a hobby horse of mine, prosecution of perpetrators. But the latest is the good judgment of Justice Madan Lokur in the MFAM case, in the Manipur disappearances case, where he's found, after the investigation of some honest Central Bureau of Investigation officers, over 1,200 cases of disappearances. And the units and personnel of the Assam Rifles and the Manipur police have been identified. After a lot of local political noise being made in Manipur, the Manipur police, some of them, about 167 of them, are being prosecuted locally. But the Assam Rifles, which is under the Union Home Ministry, Niyat, Nahi, no. Which language do you want me to use? No prosecutions. 5 years after the judgment, after not an NGO green behind the ears, wanna do good, Boy Scout did an investigation, but India's premier organization, investigative organization, the CBI did the investigation. So there's no prosecution of perpetrators. Yeah. You name any number, I can give you a whole case. I maintain a database of the number of requests for data of prosecution, and it's just, it's like me rubbing my brass lamp and hoping a genie will come out and help me. I'm no prosecution. There is absolutely no issue of even taking disciplinary action which is public, in the public domain. I am told, and I have received formal replies from the Home Ministry, that disciplinary action has been taken against this second lieutenant for the issue of rape. What is disciplinary action? When I probe further, it's a demotion and a curtailment of salary and increments for 2 years. What is the minimum sentence for rape under the penal code? There's my answer. Nothing's happening. Nothing's happening. You saw the Gogoi case where you tie a human shield in front of a jeep and take him around the village, and the chief of defense staff gives a commendation to the officer, who's later on picked up for a molestation of a young underage girl, and the whole government winks at the subject, the earlier human shield and the subsequent molestation. I can give you any number of cases. I've sent it to the various bodies, bilateral and international. For the last 14 years, the EU has not had a bilateral meeting on human rights, which was earlier an annual feature. This year in January, it was supposed to be held. One day before the meeting, it was cancelled. No scrutiny for India. Thank you very much. We are a democratic country. We're open to everything under the sun. India intervenes wherever it's useful. And I agree with India's intervention so far. I agree with India's intervention in Bangladesh in 71. Otherwise, the Pakistani army was going berserk and killing thousands of Bengali intellectuals and activists. There's no doubt that an intervention was called for and necessary. And this is what preventive diplomacy was, the idea of preventive diplomacy as enunciated by Boutros Ghali was exactly this. Yet when it comes to other issues which are not conducive to India's global geopolitical interests, suddenly it gets an attack of laryngitis. It doesn't speak. Then we're looking for the Sphinx which never speaks. Then it made a very good intervention on humanitarian relief when even medicines were not allowed to go to north and northeastern Sri Lanka. And they sent in aircraft which sent in supplies because the ships were being interdicted on the high seas by the Sri Lankan Navy. Yet, we will not say a word when 100,000 Bhutanese refugees came into India. There is no contiguous border between Nepal and India, and we turfed these Bhutanese refugees into Nepal. Nepal being too weak to say anything, lumped it, hook, line and sinker. India did not like resolution number 3074 of the General Assembly in 1973, which talked about any war crime and in situations of conflict had to be prosecuted. That's why we were very unhappy when the ad hoc tribunal on Yugoslavia was brought forward in 1993 when the Security Council set it up. I was in Rome at the negotiating conference as part of a small NGO group, which was part of to advise the drafting committee. And I know how much India put effort into to make sure that none of the important clauses ever got in. Finally, it didn't sign it along with the United States. Yet you see the United States now on the back foot on a number of things where the The most recent of it, the International Criminal Court's prosecutors' position that it can prosecute Israel for what's happening in the occupied territories. You can see how in each and every area on human rights accountability, domestic or international, India has not risen to the bar. You can see that in the discussions. I attended it only for 4 years. I didn't attend it for 13 years on the UN declaration, not a convention, a declaration on human rights defenders. Look at the wording on Article 10 on the issue of funding and what is now bugging every single civil society organization in India, the issue of funding. The FCRA, the Foreign Contribution Regulation Act. India watered it down along with Egypt. Completely watered it down. And the Norwegian chair was so tired of these 14 years of negotiation that he just let it go through. And both the Indian diplomat and the Egyptian diplomat were masters at obfuscation. I know them both very well. We definitely had a drink every once in a while in the Serpentine Bar. But that didn't make us friends. So all I'm saying is that tell me where is accountability in India or in any part of South Asia, because we all inherited the old British laws on impunity, which were done in the 1935 India Act for the first time, because British colonial officers did not want to be prosecuted by Indians going to the House of Lords. They didn't have a similar law in Malaya. They did not have a similar law in Nigeria or Kenya. They knew that the Indians were smart Alex, good at law, and who would land up in London even if the federal court in New Delhi blocked it. So they enacted it in law in the 1935 Act. And we continued it after independence. It was so very convenient. The white Sahib went, the brown Sahib came in, and so accountability, please go out the window. What is it, this cultural relativism and keeping? We are a country which for 1,000 years has had 1,000 mutinies on issues of discontent and popular will. And Gandhi put it beautifully. I'll end here. Gandhi put it beautifully. Gandhi, the exact quote escapes me, but he said that all the windows and all the doors of my house are open. The good air wafts in, the bad air wafts out. No air throws me off my feet. A ready acceptance of good ideas, of good concepts from any part of the world. This government and the earlier government, and I take no political sides, a plague on both of them as far as accountability is concerned, as far as sovereign immunity being used selectively, extremely selectively used. You did not intervene in a number of issues there. Even on Fiji, when Rambuka took over Fiji, the Indians made all the right noises, but didn't do anything. It took New Zealand and Australia to lean on Rambuka and do the right thing. I know because I was very involved in the international solidarity for Fiji, working out of London. And so there's nothing sacrosanct about the Indian position. It needs to do a lot more. And the whole issue of accountability to Parliament is not there. All decisions on ratification, on reservations, on accession to international conventions is done by the cabinet. There's no open discussion. There's no open discussion. Parliament is completely oblivious to the consequences of what it means. So they sign on the dotted line. So we signed the Torture Convention because we were under a lot of pressure in the in the mid-90s, and we've forgotten to ratify it. And it's now 25 years since it was signed, and we are still waiting for Golo ratification. So I beg to differ from Mohan Gopal on this issue. I've got too much in my file cabinet on this because I've tried to pursue cases. Habeas corpus petitions not heard in Jammu and Kashmir High Court for years together. Habeas corpus petitions. The habeas corpus petitions pending of the Bhima Koregaon case. You find all the time in the world to hear petitions of industrialists, but have no time to hear a petition of an 80-year-old sick paraplegic. It's incredible, the accountability. Habeas corpus, where is habeas corpus? Tell me where is habeas corpus and I'll tell you what is domestic accountability. Prevented detention. Which other constitution in the world, apart from that earlier Mexican constitution of that crazy party called the Institutional Revolutionary Party? I don't know how they could come up with a name like that, Institutional Revolutionary Party. Shades of Trotsky. They revoked it. Prevented detention is a finite law. It has to be ratified by Parliament every few years. Now you cannot. The UAPA is a permanent law. It's no longer like TADA or POTA. You've made prevented detention for all practical purposes there. You're not able to use any of the CRPC, the criminal procedures in UAPA adequately. So I believe that there is a time once again to revisit international accountability. And I know the UN process is extremely slow. It may not happen in the near future, but already there are other things happening, which all of us need to be aware of. The US has enacted the Magnitsky Act, which allows for sanctions against individuals and governments and corporate entities. Canada has done so similarly, the legislation, and the UK has also done similar legislation. And recently, the European Union has also decided on putting similar legislation forward. And I am aware that Australia is drafting something similar. So accountability is not going to go immediately. It is going to be very slow, but it's definitely coming. You cannot be the Indian government acting like King Canute saying, please ask the waves to go back. Thank you. Any comments, any other questions on the earlier presentations or now?
Could I come in, Ravi, because you referred to me, and I was surprised by your reference to me, because I don't think I ever said that sorry, my video is off. My apologies. I don't think I ever said that we have strong and effective mechanisms of domestic accountability. Far from it. I work very closely with the system. I know extremely well that is very weak on our part. But I've also worked for many years at the international system, and I'm not going to pin my hopes on all these sanctions being visited on us by United States and United Kingdom and European Union. That's not realistic at all. So what we need to do is we need to strengthen, as one global sort of body of lawyers and law scholars, we need to strengthen the norms that apply to all these 100 sets of problems that have been identified in this book, which includes accountability, which includes arbitrary arrest and detention, which includes rape, which includes every one of the points that you said. And we need to work on how we can, on one hand, many of those instruments need to be strengthened. What can we do as students of law to strengthen those norms? And then what can we do domestically to rely on and bring those norms into our own courts? And you see, if our constitution gets overthrown, then my comments are irrelevant. If we are going to have an official Hindu Rashtra, my comments are irrelevant. But as long as we are in a constitutional republic, then we have to build our own arguments and expose the fact that this accountability is not there, build public opinion, move the courts, come up with new legal arguments. Many of our lawyers are doing now. And so we can work together and make sure that we strengthen accountability. Accountability is extremely weak. I also said before I said anything about accountability, I said sovereignty should not be asserted by the government against its own citizens. The government must be under the rule of law. It's more than accountability. The government must be under the rule of law, not only in terms of the constitution and the statutes, but also in terms of jus cogens, peremptory norms, which are part of our domestic law, basic structure of the constitution. So my point is, if you want to give immediate relief to people, then we have to find ways of working with our institutions and getting them immediate relief. I'm too realistic and too much experience to be hopeful that international sanctions are going to change the behavior of obdurate authoritarian governments that have ruled us and continue to rule us. No, that's not going to happen. We have to strengthen, as we are doing, our own domestic institutions. That's what you've been doing. That's what I've been doing. But I never implied that we have a strong, framework of accountability at all.
I don't want this to be a mutual debate, but I just want to make quickly one or two points. Judge Albie Sachs once came to India on my invitation. This was years ago when he was a member of the Constitutional Court of South Africa. And believe it or not, the government cancelled the Constitution Club booking that I had made at the last moment. So we had to shift using cabs the whole audience that had come to the Indian Social Institute. But Judge Sachs made an important point, saying that if it wasn't for the Boycott South Africa campaign, the anti-apartheid movement, and the major sanctions that were initiated initially only by Sweden, but then caught traction thanks to people's solidarity movements across the world, they perhaps would have been under apartheid regime for a much, much longer period. The armed struggle, Umkhonto v Sizwe, was a joke, to put it mildly. Though, of course, much was made of it by the Soviet Union and East Germany, which were underwriting the costs of these boys in green in the bush. And just as an aside, we trained the officer corps in the Indian Military Academy, also and contributed to the armed struggle, which did not go anywhere. But the Swedish policy of apartheid sanctions forced Maggie Thatcher and Reagan, who were standouts, to finally toe the line, and that hurt apartheid South Africa. Now, second, on the trigger mechanism, just as a point of information, the OAU has a trigger mechanism that if an elected government is displaced by coup, then that country will be suspended from the OAU after an inquiry, and if it doesn't give a finite date for parliamentary elections and parliamentary rule to be reinstated, they would be expelled. Yet we see the example of many countries, Sudan, Egypt, and others who have completely flouted this general body resolution, which was at that point of time unanimously adopted by the OAU. So it's a question of, as Napoleon said when he displaced the Vatican, how many battalions does the Pope have? And clearly Egypt is a very powerful country militarily, and in North Africa it is the major power, and it today has the support of the West unflinchingly, because it technically displaced a Muslim Brotherhood government which was completely democratically elected. So there is a problem in this. The second issue is, how do I explain to anybody that I am a resolutionary? I am no revolutionary, otherwise I will be in human rights. I'm a resolutionary. I believe in the Constitution. But more and more, you can see that the Constitution and the avenues given in the Constitution are shut doors. How can you have the diminution of the elected government into a rump Bantusan by the union government in Jammu, Kashmir and Ladakh, not heard by the Supreme Court for 2.5, 3 years now. It has not had the time to hear a petition when it has the time to hear corporate interest petitions and Vodafone back taxes petitions in daily hearings. I ask myself, what is the priorities that the Supreme Court has, and what is the hope it gives to me that constitutional norms will be defended on the issue of internet shutdowns in Kashmir, on the internet shutdowns in Delhi, on the issue of large number of under trials who are tribals in Chhattisgarh and Orissa, where their petitions are pending for years and years and years in the high courts, not in the lower courts, in the high courts and the Supreme Court. So I am all for using domestic mechanisms wherever possible. Only on reasons of practicality, they're easier to access. They're easier to access. Making one alternate shadow report to the Human Rights Committee, it takes me 6 months of hard work along with a few staffers and interns. We can do a petition, and I have a petitioner in the Rohingya case, or the attempted deportation of Rohingya refugees. No further hearings. And only last week we pulled out refugees out of jail in Siliguri in West Bengal. And nothing's happened. So Rohingya refugees continue to be deported in spite of the petition. And I have a lawyer who's a super duper lawyer, Rajiv Dhawan, an academic and a lawyer, a well-known lawyer. And the other petitioner is Prashant Bhushan, who's no neophyte in fighting public interest litigation. Yet we have got nowhere with the petition. Nothing. And in the meanwhile, Rohingya refugees continue to be deported, even to a military junta. So I'm saying I'm all for domestic application, domestic access, domestic accessibility. But hello, I am outside the cave. I keep shouting and hollering, open sesame. There's no opening of the sesame. I sound more like Joshua blowing the trumpets outside the walls of Jericho, hoping they'll fall fast. So they aren't. So I'm speaking only from a practical point of view. Every day we are still. A high court judge tells a family whose person has been shot and killed in the Punjab, go and surrender in the same police station, and then we'll hear your case. What do I do? The case of Surinder Singh Fauji, still pending. And a former judge, before he was elevated to the bench, argued the petition on behalf of the victim, so Mr. Sodi. So I am all for, but the domestic access is not there. And ask any activist actually approaching the courts, not reading. There are NGOs who are rehashing stuff that other lawyers, activist lawyers, and NGOs do, not them, but lots of lawyers the Anand Grovers of the world, the Prashant Bhushans of the world, the KG Kannavirans before he died. There's lots of them, the Vrinda Grovers of the world, lots of them who are Indra Jaisinghs, who have some relief, but ask them how much relief have they got in major cases. Has Anand got any case in the relief in the Bhima Koregaon case? None whatsoever. He's there, he's fighting it out. But the government is very worried. Even a letter to a special rapporteur, which may not feature in the special rapporteur's annual report in 3 lines, embarrasses the government much more than a Supreme Court petition here. So obviously I will go to the special rapporteur's report, because a 2 lines report that he or she gives to the General Assembly is more embarrassing to the government than all the Supreme Court petitions I do. And I've seen it in so many places. The diplomats come to me and say, please, you need to rethink what you're doing on this issue. So they are not, and this is exactly why they are now stopping NGOs from going to international fora. The Priya Pillai is not the first person who was stopped. Tons of NGOs have been stopped from going. Tribal activists, Dalit activists, activists from the Northeast. Khurram Parvez has been, in Kashmir, has been offloaded aircraft. It's happening all the time. So if you do not care about international scrutiny, then what's the concern? Let us go and yell and mumble and grumble in any international fora. If nothing else, if we don't get an international fora, I'll climb on a soapbox in Hyde Park. Why are you worried about some old fogies writing a letter to the House of Commons? So there is a certain embarrassment that the government of India, irrespective of the political party, feels. And if you are advancing human rights and the rights of the people, the most marginalized, who do not have voices, would the tribals displaced in Orissa against this British multinational Vedanta owned by a group of non-resident Indians ever succeed if it wasn't for the campaign in Britain? So that's what I'm saying. Didn't the Indian freedom movement benefit, and wasn't Roosevelt took it up with Stalin and Churchill, and an obdurate imperialist like Churchill at the Yalta conference because of the campaign of the India Independence League run by J.J. Singh in the US, or Krishna Menon in the India Independence League in the UK, who turned the whole Labour Party stance for Indian independence, because we must remember that until 1930 it was only the ILP, the Independent Labour Party, not the British Labour Party, which was supporting independence. It was Fenner Brockway and others who were campaigned by Krishna Menon who brought this. So international campaign has always been part of our freedom movement, has been part of our movement during the emergency. If it wasn't for the Socialist International, what would we have got? A voice here, or even the predecessor party of the BJP. And it sent Subramaniam Swamy to campaign abroad. It create the Friends of the Jansangh in London, run by a minister, Hasmukh something, who later on became a minister in Gujarat. International campaign has been part of our thing. So I don't see suddenly this whole sovereign notion and sovereignty notion, oh, we will fend off all intruders, deepen the moat, heighten the walls, and repel all borders kind of strategy by the diplomats in India and the Home Ministry bureaucrats. Water will permeate to the level it finds when there is a problem. And we need to acknowledge these problems, address them honestly, and put mechanisms, legal and statutory mechanisms to address them. Then what is the National Human Rights Commission? It's a joke. Please read the 1993 parliamentary debates on the setting up of the National Human Rights Commission. Mr. Vittal Gadgil, who was also apart from being a thing, was also a Congress spokesperson, for once confessed on the floor of the House, saying that this is a buffer against us and international scrutiny. That was the purpose of the National Human Rights Commission. That's not your best foot forward in terms of domestic accountability. That's definitely not your best foot forward on domestic accountability. To me, domestic accountability is the first step. But when domestic accountability does not work, I shall tap all doors which can give me succor. I better stop there, otherwise I can go on and on the subject. I'm sorry.